Mr. President, I rise today as the Senate has been called upon to fulfill our constitutional duty to give advice and consent on President Trump's nominee to the Supreme Court, Brett Kavanaugh. Now, in the past, presidents worked with a bipartisan Senate to appoint someone who understood the importance of precedent and transparency, who respected the independence and integrity of the highest court in the land. Unfortunately, that did not happen during this nomination process. Instead, the process was flawed to fast-track a nominee without a full vetting for political gain. Brett Kavanaugh was handpicked by the Federalist Society, a right-wing lobbying organization dedicated to overturning Roe versus Wade. Why? Because, as he has made clear on several occasions, President Trump wants to stack the court with justices who will overturn Roe versus Wade. Now, I am new to the Senate, and as long as I've been here, I've been told this is not regular order. And so as we went through this confirmation hearing, unfortunately, I had found it, along with my colleagues, to be fast-tracked. And I take very seriously my role to advise and consent when it comes to a nominee, and I think we all, as senators, have equal votes. And we should all have access to all of the information, a full vetting of any nominee who wants to sit on the highest court for a lifetime appointment. Think about this, the highest court. There's only 9 members, lifetime appointment. And this is something that we should all look for the right person, and everyone should have a full vetting. But this hearing was fast-tracked. Not only was it fast-tracked, we did not have access to all of the documents necessary to determine whether Brett Kavanaugh not only had the correct judicial philosophy, but the judicial temperament and impartiality that is necessary for somebody to sit on the highest court of the land. Not only were we limited in the number of documents, but what little documents we did get, unfortunately, some of them were marked committee confidential. In an effort to prevent members from using documents to question the witness by unilaterally declaring them committee confidential, many of my colleagues in the Senate Judiciary hearing were unable to adequately question Judge Kavanaugh. Now, I am told that that process of committee confidential is without precedent. Republicans claim that Chairman Leahy also accepted documents on a committee confidential basis during the Kagan nomination. Those documents were processed by the National Archives, not private partisan lawyers, and Republicans did not object. By the time of her hearing, 99% of Elena Kagan's White House records were publicly available and could be used freely by any member. In contrast, the committee has only 7% of Brett Kavanaugh's White House records, and only 4% were made available to the public. No Senate or committee rule grants the chairman unilateral authority to designate documents committee confidential and prohibit their public release. Neither the rules of the Senate nor the rules of committee authorize unilateral designation. There was no committee action, and Ranking Member Feinstein sent a letter stating she did not agree with a blanket designation and asked the chairman to work with her to identify a subset of documents that should remain confidential, and he refused. But the chairman then released thousands of Mr. Kavanaugh's documents himself. Specifically, he posted thousands of documents that had previously been marked committee confidential after consulting with Mr. Burke. If these were confidential and committee confidential documents, then the chairman's actions also would violate Senate rules. The Senate rule on executive sessions provides a penalty for disclosing the secret or confidential business or proceedings of the Senate, but it requires a vote of the committee action to conduct confidential business or proceedings. Democrats cannot be held to a different standard. Chairman Grassley has asserted that Mr. Burke had sole authority to decide what documents may be used to question Judge Kavanaugh and sole authority to decide which documents may be released to the public. However, he has failed to cite any rule or statute that gives Mr. Burke any authority. We should not have moved forward with hearings when we only had a fraction of the nominee's record, and the most significant documents that we had remained hidden from public view. Now, the chairman claimed that he provided ample opportunity for Democrats to clear committee confidential documents for use at the hearing, but he refused the request of several members to make documents on a number of topics public. And I also want to make it clear that as I watch that hearing, there are allegations that members of the Senate didn't even show up to take a look at these confidential documents, so why were we complaining? Well, I'll tell you what, Mr. President, I showed up. I was there for 3 days looking at all of these documents because I thought it was necessary, even if we were going to be limited in what we could see and what we can talk about. I had a voice equal like everyone else, and I should have access to those documents and figure out if I had the opportunity to talk to Judge Kavanaugh or talk with my colleagues about it, then I should have access to those documents. But even when we had access, the chairman demanded that Democrats send him their documents for pre-clearance by his staff, President Bush's lawyers, and the White House. Now, my understanding is never before has minority members of the committee been required to identify and pre-clear the topics and documents that they want to discuss with the Supreme Court nominee, with the chairman, or outside private lawyers, or the White House. Never has the majority asserted unilateral authority to pre-clear what issues the minority party can even ask a nominee. The idea that Democrats have to ask Republicans to pre-clear their questions in a Senate Judiciary Committee hearing is outrageous. If the chairman, Bill Burke, and the Trump White House were truly interested in a transparent process, Mr. Burke and the White House could make the White House counsel records public now, as President Obama and former President Clinton did for the Kagan nomination. But we still don't have access to all of the documents. We still have a process that is broken. We still have a process that unfortunately did not provide all of the senators the opportunity to have a full vetting of Brett Kavanaugh. Now, I took my time. I reviewed Judge Kavanaugh's record. I looked at his cases, his written statements. I listened to his comments in the hearing. I went and reviewed the documents in the committee confidential. I wanted an opportunity to meet with him. Unfortunately, that never happened, so I could question him myself. And based on all of the information and based on taking my time, like I did with our previous nominee, because it is that important that we get the right person on the bench. But in his statements and in his writings and opinions, it was clear to me that Brett Kavanaugh has shown that he does not respect precedent. He does not respect a woman's right to choose. He does not respect workers' rights. If confirmed, I believe that Judge Kavanaugh's extreme activist judicial philosophy will pose a threat to women, our environment, our constitutional separation of powers, and our fundamental civil rights. But it's not just Brett Kavanaugh's judicial philosophy that troubles me. Last week, Judge Kavanaugh testified before the Senate Judiciary Committee to defend himself against sexual assault allegations. He was asking for our vote for a lifetime appointment to the Supreme Court. one of the deepest and most profound honors this nation can bestow upon a citizen. This nominee was interviewing for a job in front of the American people, and he was belligerent, evasive, and aggressive. This nominee, who currently sits as an appellate court judge on the D.C. Circuit Court, disregarded all demeanor and respect for impartiality and independence by accusing the Democrats of engaging in, and I quote, a calculated and orchestrated political hit fueled with apparent pent-up anger about President Trump and the 2016 election, fear that has been unfairly stoked about his judicial record, revenge on behalf of the Clintons, and millions of dollars in money from outside left-wing opposition groups. He then took it even further by stating, and as we all know in the United States political system of the early 2000s, what goes around comes around. What goes around comes around? Are those the words of an impartial judge? Of course not. During the question and answer period with the senators, he was belligerent, impatient, and aggressive towards anyone who pressed him to get to the truth. His demonstrated lack of temperament and impartiality is another reason why I cannot support him. It is also why over 2,400 law professors from respected law schools across this country penned a letter to the senators to state that the Senate should not confirm Judge Kavanaugh. Some of these very law professors who also appeared before the U.S. Supreme Court. Some of these very law professors who also practice and teach at Yale and Harvard. They wrote, and I quote, "Judicial temperament is one of the most important qualities of a judge. A judge requires a personality that is even-handed, unbiased, impartial, courteous yet firm, and dedicated to a process, not a result." They further stated, at the Senate hearings on September 27th, Judge Brett Kavanaugh displayed a lack of judicial temperament that would be disqualifying for any court and certainly for elevation to the highest court of this land. And former Supreme Court Justice John Paul Stevens, a Republican appointed by President Ford, stated similar concerns. When I watched Judge Kavanaugh's testimony, I didn't see a fair and impartial justice. I saw a man who is blinded by rage and ideology. As a sitting judge, Brett Kavanaugh knows better. He knows better. His accuser, Dr. Christine Blasey Ford, testified before the Senate Judiciary Committee for 4 hours. She was poised, serious, and credible in recounting what was clearly one of the most scarring, traumatic experiences of her life, and she did it on live television for all the world to hear. She did it in the face of death threats. She did it at the risk of damaging her credibility and career. She had nothing to gain. She has done a profound service to everyone whose life has been touched by sexual assault or abuse. Dr. Ford, I believe you, and I thank you for your courage in coming forward. Now, I believe in a fair and independent process for people who have been accused of serious crimes like sexual assault. And the process should include a neutral investigation that is thorough and nonpartisan, because it will hold a perpetrator accountable or exonerate the falsely accused. But that fair and independent process did not occur this time. I am glad some of my colleagues stood up to make sure the FBI had a chance to reopen its background investigation. But I'll tell you what, after reading the recent FBI report, it is clear that Republican leadership limited its scope. And I say that as somebody who not only has been a prosecutor for 10 years, 8 years the Attorney General of the state of Nevada. who conducted criminal investigations and oversaw peace officers who did the same thing. Because what they did not do, they did not interview Dr. Ford, nor obtain from her the important medical records that would corroborate her testimony. In fact, her attorneys wrote to the FBI, offering up not only additional witnesses, but making the statement that if they were to interview Dr. Ford, she would have also provided corroborating evidence, including her medical records and access to the phone from which she messaged the Washington Post about Judge Kavanaugh's assault prior to his nomination to the Supreme Court. And I'm here to tell you, corroborating evidence isn't just in the form of witness statements, it's in the form of documentation that is key. And that was never recovered by the FBI. And I'll tell you, the potential witnesses that potentially the FBI could have talked to, we know because they came forward out of a civic duty and they went public, and the FBI still did not talk to them. We know Dr. Blasey Ford's husband, Russell Ford, he said that Christine shared the details of the sexual assault during a couples therapy session in 2012. She said that in high school, she had been trapped in a room and physically restrained by one boy who was molesting her while another boy watched. And Dr. Ford's husband said, I remember her saying that the attacker's name was Brett Kavanaugh in 2012. 2012. Along with her husband, Adela Gildo-Mizan, a friend of Dr. Blasey Ford's, came forward and said, in June of 2013, she said, Christine Ford, Dr. Ford, said that she had been almost raped by someone who is now a federal judge. She told me she had been trapped in a room with two drunken guys and that she then escaped, ran away, and hid. And a third witness, and somebody who could have corroborated Dr. Ford's statement, Lynn Brooks, Brett Kavanaugh's college friend, who said, there is no doubt in my mind that while at Yale, he was a big partier, often drank to excess, and there had to be a number of nights where he does not remember. So I know, and unfortunately, too often we have seen in this particular case an FBI supplemental report that was not thorough. In addition, after I reviewed the summary of the report and realized we were missing information, the additional corroboration would have also gone to Debbie Ramirez's allegations. But they did not interview, the FBI did not interview important witnesses to corroborate Debbie Ramirez's allegations. We now know, because they've been, again, willing to come forward after seeing what has been happening through these hearings, Kenneth Appold, Kavanaugh, a suite mate for Brett Kavanaugh at Yale, who is now a professor at Princeton, stated, I can corroborate Debbie's account. He said, I believe her because it matches the same story I heard 35 years ago, although the two of us have never talked. And Professor Appold was never interviewed. Likewise, James Roche was also a roommate for Brett Kavanaugh. And he said, although Brett was normally reserved, he was a notably heavy drinker, even by the standards of the time, and that he became aggressive and belligerent when he was very drunk. And likewise, Chad Ludington, a college classmate, came forward. I can unequivocally say that in denying the possibility that he ever blacked out from drinking and in downplaying the degree and frequency of his drinking, Brett has not told the truth. but they were not interviewed by the FBI. So now, because we only have limited information, all senators are left with a lack of a full understanding of the facts surrounding the allegations against Brett Kavanaugh. The questions swirling around Brett Kavanaugh get at the very heart of our responsibility as members of the United States Senate. We are not here to be a rubber stamp on the president's nominees. We are a check and balance on his power. We are here to work with him to make decisions that are right for the American people. That means we listen to our constituents. That includes women and men who have buried their experiences of trauma for far too long. I have received letters from my constituents from all over Nevada sharing their stories of survival. I heard from men and women in our military who were struggling not just with the effects of PTSD, but with the experience of being sexually abused. I recently met with women who led the campaign to codify a woman's right to choose in the Nevada state constitution, and they all asked me to oppose Brett Kavanaugh's nomination. And I stand with them. I stand with survivors. I stand for the right of every American woman to make her own health care decisions. I believe Dr. Christine Blasey Ford. I believe in the integrity and independence of our judicial system. I condemn Brett Kavanaugh's confrontational and partisan behavior. And I condemn the handling of this nomination by Senate Republican leaders. We must work together in a bipartisan way and restore our constitutional role of advice and consent. This is about something bigger than any one nominee. It's about the integrity of our institutions. It's about the core functions of our democracy. We can't allow partisan politics to eat away at the checks and balances enshrined in our Constitution. We have to return to common decency and regular order. Anything less is below the dignity of the American people and the great Constitution we swore an oath to faithfully support. I encourage all of my colleagues to join me in voting against this temperamentally unfit nominee. Thank you, Mr. President. I notice the absence of a quorum.
The clerk will call the roll.